Ini kenapa dulu? Ini kena rapi dulu sudah kebulan nanti. Kalau terus kebulan nanti. Di bilang lagi. Oh mama. Halo. Diki gol. Yes, so second just law. Part-1, DB. Division bench. What is it? So, for admission, item number 1.
Which is should be the last occasion. Okay, this directed to.
Yes, what is the status of the?
I'm informed that charge sheet has not been filed.
Okay, now have you extended, sought for extension of the time?
Since the matter is pending before the High Court, so there's no order such.
No, there's nothing
Only the
forbidding you from asking for that. Under such circumstances, the person concerned would be entitled to default bail. isn't it? That's the mandate of law.
Yes, my lord, in regard to extension, uh, it's only in regard to the NSA detention.
So it is only on because of the NSA detention he is under detention.
Yes.
Yes, what are the other grounds? apart from
Lordships, I'm asserting the impugned detention order on merits as well as on technicalities. On technicalities, besides the ground that the detention order was passed while the detainee was still under judicial custody, the second ground that I'm taking is the ground for detention and the enclosures were not uh, communicated to the detainee in the language that he could understand, Lordships.
There's the judgment of the division bench in that case, handed by Justice Tulia.
Lordships,
The
I'm
division
relying
bench
on
judgment, when he says that it has to be communicated in the language in which the detainee understands.
Lordships, I'm relying on Gauhati High Court Infal bench case. Tekelambam Ongbi Mombi Devi. Yes.
There's a division
The
bench
same-
judgment. There's a division bench judgment of our court in a recent judgment on this aspect, in which it is required to be done. You have the judgment which I have written on the case of Herod Chang.
Yes, Lordship.
In that-
I'm also relying on that.
Yes, in that there is a judgment of the division bench I have referred to of Chief Justice Julia. What the name of the case? And that judgment have relied upon the Supreme Court judgment in 1961 or 62, wherein it has stated it has to be informed in the language in which he understands.
Yes, Lordship. That judgment is Pangsha Yingle versus State of Nagaland.
Yes,
That judgment is Pangsha Yingle versus State of Nagaland, reported in 2021.
that is there. That is Herod Singh.
That is there in the Herod Chang's case.
Yes,
Lordship. We
and
have
then
referred to
in that judgment, there is a reference to a division bench judgment. See, of Gauhati High Court, it's a recent judgment, I think of 2021, I suppose. It's there. Give it to me, I'll find it out. You have given the citation of this book.
Yes, Lordship.
What is that?
2022 2 GLT 86.
Adam Ali judgment. 2021
correct,
3
that's right.
GLP 564. Yes, I told you, na? In this judgment, Adam Ali, kindly come to paragraph 23, has referred to the 1962 judgment, held if the grounds of detention are communicated to the detainee in any other language than the language he understands, that would not amount to communication of the grounds of detention as visualized under clause 5 of article. You seen it? Paragraph 23 of the same judgment.
Yes, Lordship.
That is the report that this judgment was taken into account in the case of Adam Ali. You have this book?
No.
What is it?
Isn't it?
Yes,
Isn't that the judgment?
Lordship.
This is your judgment on the question that it has to be communicated in the language in which the detainee understands.
Yes, this is one judgment. I'm relying on another judgment also, Lordship. Besides this.
We found by that judgment, are we
Yes,
not?
Lordship. Yes.
Or do you want us to write a judgment containing what you call a lot of citations and all? Your basic idea must be to get your person relief as soon as possible.
Lordship.
So that is one. Then next point.
Lordship, while still dwelling in that point, the detainee, may I submit that the detainee is uneducated. He has no formal education. Lordship may kindly see the affidavit in opposition, annexure A, which is in page 10.
Hmm.
Here the acknowledgement certificate, married Lordship. I, Mr. So-and-so, son of so-and-so. I, Mr. Thorer, who is the detainee, son of so-and-so, village so-and-so, PO so-and-so, district Senapati, state Manipur, acknowledge the receipt of one set of detention order number so-and-so dated 26 July 2023 and its enclosures, and certified that the contents have been explained to me in the language I understand, that is Nagamese, in the presence of the undersigned witness. Lordship, meaning thereby, the detainee understands only Nagamese and his local dialect, which is Tumai. I have categorically stated in my affidavit also, Lordship. So the enclosures, it runs into 71 pages, Lordship, including the impugn detention order. So it was provided only in English language.
So if it is in English language, what is the other script for Nagamese?
There is no script as such, Lordship, but it was not translated into Nagamese where he could understand.
Who says that he could not understand? Because this is an affidavit filed by the father.
Yes, Lordship.
So if it is an affidavit father,
Yes.
how can we have a subjective satisfaction that that person concerned did not understand?
Lordship, with the authorization of the detainee, the father has filed because the detainee is in jail.
David,
Now, he has no formal education and therefore he does not understand English. Lordship.
so in what language? So here it says that it has been explained to him in Nagamese.
Lordship, I'm relying on the judgment wherein the communication, the definition of communication has been explained by the Supreme Court, which says that it should not only be in verbal, but it should be in written. Lordship is well aware of.
Well, that is why
Yes.
I asked you, what is the script for Nagamese?
English I know.
So
Like English letters.
there's no script as such. Lordship.
So therefore, does your person
Yes.
know how to read Nagamese or the local
Yes.
dialect?
Lordship, he can somehow communicate in text and understand Nagamese.
Therefore, I asked you whether you are saying that he or she,
Lordship.
he is illiterate or is not, or literate, but cannot understand, read.
Lordship, categorically mentioned that when it comes to English, he does not understand.
The alphabets are used. English alphabets are used to write Nagamese. What alphabets are used to write Nagamese?
What else? That is what I'm asking you. What is the script of Nagamese? Is it in English? Is it the Roman letters which have been taken into account in
No, Lordship.
Nagamese?
In English alphabets only.
English. So therefore, you say that he can read those English alphabets.
That's what I was made to understand, Lordship.
Now, if he can read those English alphabets, the question here is, this categorically says that it has been explained to him in Nagamese.
Yes, Lordship.
Then,
Lordship, my only submission is that as per Supreme Court's definition, the communication would not be only explaining to the detainee in the language that he understands, but also the enclosures and the detention order should be in English language.
where does this?
Lordship. 1991, 1 GLR 422. Srimati Tekhalanbam Ongbi Mombi Devi.
But you
versus-
say Supreme Court.
My apologies, but I may be allowed to read the content.
Yes.
Para 7, Lordship, Para 7. This point also came up before Constitution Bench in Hadi Bandhu Das versus District Magistrate Kutak, AIR 1969, SC 43. In that case, the grounds in support of the order served on the detainee run into 14 type pages. These were in English language, whereas the detainee did not-
Before going there, let us go
Lordship.
to paragraph 2 of the judgment. Yes. Yes. What is it? Read it. Paragraph 2.
The case of the petitioner is that the detainee is a Manipuri and he can only read and write Manipuri language. He is not familiar with English. 2 days after his detention on 26/19/1990, he was furnished with the grounds of detention and the relevant documents running into 33 pages. All those were in English. As the petitioner did not know English, he was unable to understand the contents thereof, and as such, he could not make any representation. He was thereby deprived of the constitutional safeguard under Article 22(5) of the Constitution.
Now tell me, did you submit a representation?
Yes, Lordship.
Where is it?
Pardon me, Lordship.
Where is your representation?
Lordship, my representation is in annexure 5, page 30 of my recast petition.
Now this representation is in English. Tell me. How do you bring it within it?
Lordship, I have not, I was communicated, the detainee communicated to me the facts in Nagamese, and accordingly, I have condensed it to English language and
Now in paragraph, that means, are you saying that
Lordship,
paragraph number 4 of your representation are the grounds of detention, which the detainee explained to you in Nagamese, and then you made it in English?
Lordship, may I
And
explain
that
this,
means,
Lordship?
if that be so, the detainee definitely understands this.
Lordship, may I explain this, Lordship?
Hmm.
Before the detainee was sent to the to central jail, I've made the detainee.
So you explain to him the grounds of detention. You see, you have written, these are the grounds of detention. Meaning thereby, he must have, detainee must have understood the grounds of detention. Now, if you see paragraph number 2 of that judgment, it categorically shows that that person was not in a position to submit a representation in view of the fact that he did not understand head or tail about what was served upon him.
Lordship, my only submission is that the script was not, the detention order and the enclosures were not served to him in English language.
So how does it make a difference? Because of the fact that it was explained to him in Nagamese. Therefore, I asked you, is the script the same? If you can understand ABCD. Because if you can read, if the script of Nagamese or any other language which he understands is the Roman letters, then under such circumstances, can you bring it within the form?
No, Lordship.
Then
Lordship,
how can we apply the judgment?
Lordship, in that case, may I proceed to the next
Point.
point, Lordship,
Fantastic.
next ground. Lordship, the next ground is I have submitted representation to the central government and the state government. And the representation was submitted on 26/9/2023 through the jail authority, Lordship. The Lordships will find the receipt of the representation
Page 36.
in page 50, annexure 6, yes, Lordship.
No, page 36, it is there.
Oh.
Signature attested by the jailer on
Yes,
26.
in that also it's there, Lordship.
Page 50.
Page 50, Lordship. A separate receipt to that effect has been
Then,
given by the jail authority.
and it was disposed of when?
Firstly, on 3rd October 2023, Lordship will find this order, rejection order issued by the Home Secretary in page 51, annexure 7, Lordship. Thereafter, in page 52, Lordship, annexure 8, the Chief Secretary to the state of Nagaland has rejected the representation on the ground that there is no valid ground for revocation of detention. However, Lordship, the ground that I'm taking here is that although on 26/9/2023, representation has been submitted through the jail authority to the central government. Till date, the central government has not considered or disposed of the representation. And before this honorable board also, the central government has not filed its affidavit. Therefore, on the ground of inordinate delay, Lordships,
The central government till date have not disposed of the representation.
they have not disposed of the representation till date, Lordships.
Now let us see the act. The representation is required to be submitted in terms with the act.
Lordships,
Show me that. And here the best part is the central government is not represented. Which act?
PIT NDPS, prevent.
No, not NDPS Act won't help you. We have to look into the other act under which you have been detained.
Yes, Lordship, I've been detained under PIT NDPS, prevention of.
Where is that act? It's a part of that NDPS Act, no? Even in your representation, you have not taken the ground that you could not understand what is the contents of the documents.
Lordship.
So that ground cannot survive. NDPS Act. Yes.
Section 12, of the Prevention of Illicit Traffic in NDPS Act. May I read, Lordship?
Just one minute. Yes, section 12.
May I read? Section 12, revocation of detention orders without prejudice to provision of Section 21 of General Clauses Act 1897. A detention order may at any time be revoked or modified, A, notwithstanding that the order has been made by an officer of a state government, by the state government, or by central government. B, notwithstanding that the order has been made by an officer of the central government, or by the state government, or by the central government. Number two, the revocation of the detention order shall not bar making another detention order under Section 3 against the same person.
So you're right under section 12.
Lordship, my understanding and my humble submission is that, Lordship, the central government is empowered with the power to revoke representation. Therefore, it is the central government is duty bound to consider my representation.
Okay. Now, you have any judgments on this point?
Lordship,
The non-consideration of the representation by the central government?
Lordships.
Now, show me one thing, this is also made to the joint secretary, no? Ministry of Finance
Yes, Lordship.
and Department of Revenue. They have the power to reject it, to grant you.
Yes, Lordship.
Okay. And the fact that it was not sent, assuming you have given it
Yes,
and
Lordship.
they have not sent it to the central government, then also it takes away your right under 12.
Yes, Lordship, that is sufficient. Lordship, the case that I'm relying upon is 1993 3 SCC 194, done by Dulabai Sheikh versus District Magistrate Ahmedabad.
Not in the book list. Not given the book list.
I've given, Lordship.
Your trump card judgment, you are not given it in the book list.
Lordship, I've submitted.
Okay, let me look it from
Serial number 4. Serial number 4 on the book list.
Nineteen
1996 3 SCC 194.
1996.
3 SCC.
Oh, you have it? Oh, yes, tell me.
I'm relying on para 16, para 23, 24, and 25.
Para 10.
There are 16 Lordship.
Para 10 then?
No, Lordship, para 16,
Okay.
para 23, 24, and 25. Married Lordship.
Yes, para 22.
There are 23 Lordship.
23.
Yes.
Hmm.
Married Lordship. 23. Apart from the above representation dated 2/9/1995, which was made to the central government, could not dispose of for want of comment from the state government. It will be noticed that the representation was lying with the state government from 2/9/1995 to 27/9/1995, and it was on that date that it was sent to the central government, which received it on 4/10/1995. The central government, in spite of its telegrams and reminders, was not furnished the comments by the state government for over a month. The comments of the state government were received by the central government on 6/11/1995, and the representation was disposed on 8/11/1995. This was after about 2 months. This again is a glaring example of the lethargy on the part of the state government, as a result of which the petitioner's representation could not be disposed of expeditiously by the central government, which with the obvious consequence that the petitioner's right under 225 of the Constitution, read with Section 8 of the Act, was violated. 24. In the second case also, the representation dated 23/8/1995 made by the detainee was forwarded to the central government by the state government under its letter dated 19/9/1995, which was received on 21/9/1995 by the central government, which by its telegram dated 22/9/1995 and reminders dated 29/9/1995 and 5/11/1995 called for the contents of the state government. The state government, true to its colors, sent the comment on 18/10/1995. The representation was rejected by the central government on 19/10/1995. This is after 1 month. The representation thus remained lying with the state government from 23/8/1995 to 19/9/1995, and when it was ultimately sent to the central government, the comments were not furnished by the state government till 18/10/1995. Thus, in this case also, the guarantee of early disposal of representation set out in Article 22(5) was infringed. 25. Black marketing is a social evil. Persons found guilty of economic offenses have to be dealt with a firm hand, but when it comes to fundamental rights under the Constitution, this court, irrespective of enormity and gravity of allegations made against the detainee, has to intervene, as was indicated in Mahesh Kumar Chauhan's case, and in the earlier decision in Prabhu Dayal Deora versus State of District Magistrate, in which it was observed that the gravity of the evil of the community resulting from anti-social activities cannot furnish sufficient reasons for invading the personal liberty of a citizen, except in accordance with the procedure established by law, particularly as normal penal laws would still be available for being invoked, rather than keeping a person in detention without trial. And in 27, on merits, Lordship. In view of the foregoing discussions, we have considered the arguments of the council on both sides by our order dated 21/11/1985 as aforesaid, allowed these petitions and have now recorded the reasons therefore.
Now you submitted the detention, the representation on 25/6, 25/9,
26/9.
26. And who is the authority to reject or refer or give by the or take action on the basis of the representation?
What's it, my understanding is.
Because
that
there
as
are
per
two
section-
orders.
Section 12
Hmm.
of the NDPS. The central government as well as the state government.
It is the
First-
state government. The state
As-
government, would it mean the special secretary or the chief secretary? Because the chief secretary rejected it
Yes.
sometime much later. The
Yes.
special
got it.
secretary who has filed the affidavit
Yes.
have done so on this particular date, what do you call, 310. Which is almost 9 days. We have 4 days and another 7 days. Within 7 days, this was done, 310.
On 3rd October.
Whereas the petitioner, the chief secretary, had done it on 1610. And there is no explanation in the affidavit as to why the chief secretary had to do it. Isn't it?
Okay.
Kindly come to paragraph number, page number 4 of the affidavit filed by the respondent. Last verse. Subsequently, the detainee representation was received by the deponent through the senior superintendent of Swansea. However, the said representation was carefully examined by the state government, but being found to be not be no merit in the prayer, the authority had rejected the request by an order dated 310. Thus, considering all these aspects of the matter, the confirmation order dated here was passed to Swansea. Now, who has why did the chief secretary also reject? On 16th. Yes, government council. Why there are two rejection of the representation?
My lord, the special secretary is the attending authority.
So he could not.
Yes,
So it has to be done by the
chief secretary.
chief secretary. Now, why there has been no explanation out here that for almost 14 days, 16 plus another 4, 20 days.
Because in the affidavit, only the attending authority has given the.
Then under such
justification.
circumstances, wouldn't it be a case of a delay? You should have taken it forthwith. There is not a single explanation in your thing. Now, secondly, did you forward the copy of his representation to the central government?
Yes, my lord.
And why the central government has not done it?
I have no idea, my lord.
The central government has
Because-
also not asked for the comments.
Because for consideration or for disposal of the representation, it is independent.
Huh?
So it is independent decision has to be taken by.
Understood.
central and the state.
Understood, but the detainee has no power or doesn't have the means to serve the central government. It has to be done routed through the jailer,
Yes, my lord.
and it will be routed through the jailer, then to the state government, and then to the central government. Oh, true, whatever
No,
may be.
From central government only from.
Now, the central government have not taken a decision.
Yes,
There is no explanation of the delay of 20 days. And the affidavit is absolutely on a wrong presumption that the rejection the rejection of the representation could have been done by the detaining authority. In fact, is the special secretary home, the detaining authority?
yes, my lord.
No, the
Because
detaining
my lord,
authority
here-
will be the
No, this is
commission.
NDPS case.
Huh?
It is NDPS case.
Okay,
So that is why it is the special secretary who is authorized to issue the detention order.
so the state government, there's no explanation why it took 20 days.
Well, only the detention, since special secretary has disposed the representation, only the special secretary has explained
Understood, but there is no affidavit from the government.
this government.
You will serve the notice.
Yes.
You are also appearing for the government.
Since the other respondents are relying on the affidavit filed by the special secretary.
Then very well, it is much better for the petition if you are relying on the affidavit filed by the detaining authority. Here, the special secretary is number 2. Number 1 is the chief secretary. The
Yes.
chief secretary has not filed any
Yes.
affidavit explaining why it took 20 days.
Yes.
So we set aside this detention.
My lord, may I please your lordship? I don't think my learned friend has completed his submission.
Yes.
Then kindly allow me to make my submission.
Yes, please. We are satisfied with this, John. Let's see if he is in a position to make us feel that we are wrong. Then again, I'll trouble you.
My lord, before I make my submission, kindly allow me to read the act. The Preventions of Illegal Traffic in Narcotic Drugs and Psychotropic Substance Act 1988. Section 3. Section 3. May I read?
Yes.
Power to make orders tending certain persons. Clause 1. The central government or a state government or any officer of the central government not below the rank of a joint secretary to the government, specially empowered for the purpose of this section by that government or any officer of a state government not below the rank of a secretary to that government, specially empowered for the purposes of this section by the government may, if satisfied, with respect to any person, that with a view to preventing him from engaging in illegal traffic in narcotic drugs and psychotropic substance, it is necessary so to do, make an order directing that such person be detained. Now, clause 2, when any order of detention is made by a state government or by an officer empowered by state government, the state government shall within 10 days forward to the central government a report in respect of the order. Clause 3. For the purpose of clause 5 of Article 22 of the Constitution, the communication to a person detained in pursuance of a detention order of the ground on which the order has been made shall be made as soon as may be after the detention, but ordinary not later than 5 days and in exceptional circumstances, and for reason to be recorded in writing not later than 15 days from the date of detention. My lord, these are the procedure that to be followed while passing a detention order. My lord, detention order was passed on 26/7/2023. On the same day, 26/7/2023, all the records, all the detention order, the requisite documents, everything was furnished to them. That is on 26. It is substantiated by the acknowledged receipt. And in the language he understands. That is the Nagamese. The authority has already explained. So since the detention, everything grounds of detention, right of the detainer was explained, the detainer has submitted representation on 26/9/2023. So as per the act on time frame, we have submitted, we have given the furnished the documents. On that, they have submitted representation. And the representation was rejected on 3/10/2023. It took 8 weeks.
Three?
Yes, by the special secretary.
No, does the special secretary have the
Yes, yes.
power?
No, my lord, it
No,
is,
no, no.
yes,
No, no, no.
and by the
Yes,
chief secretary.
we are concerned therefore,
Yes,
can the representation be rejected by the special secretary?
my lord, the representation is addressed to the special secretary.
No, the representation has to be to the state government.
Yes, but it was addressed to the special secretary.
Then
Your lordship, you can see the representation. It is addressed to the special secretary.
kindly see copy to the chief secretary.
Yes, copy has been given.
So no, he may address to any ABC. But the rejection of the representation has to be made by whom?
Since the representation addressed to the special secretary can also dispose the representation.
Yes. Then therefore submit. Can the special secretary dispose, being the detaining authority, submit, reject the representation?
If there's no ground, then the special secretary can reject. And since the
A
copy of,
representation is given against, can it be given to the same person who has detained?
no, but it is addressed,
Maybe,
yes,
you see, we can't go into those aspects,
Yes.
but it has a copy was duly marked to the chief secretary. And the fact that the chief secretary has rejected the representation on 16/10/2023 also shows that he has duly received the representation.
yes, my lord.
Then
Yes.
why does it take 20 days to do so?
So, yes, chief secretary disposed the representation on 16 days. Yes, there is a delay of 20 days.
Unless there is an explanation,
Yes,
which is not there. And another thing,
yes.
Mr. Counsel, kindly see, come to section 12. 12. A person has a right to submit representation to the state government, and the state government would mean the chief secretary, not the special secretary, or as well as to the central government. The petitioner have duly done so. It was the necessity on the part of the state government as well as the central government to dispose of the representation, taking into account that a person who is in illegal detention or in preventive detentions, his rights are completely different from a person who is in other normal course of events. So under such circumstances, if the central government is not disposed of, one, if there is a delay on the part of the state government without an explanation why it took 20 days, it can be a right under Article 22 is being violated. Now, therefore, you see Section 12 properly. If there is on the ground of revocation, if it is revoked also by the state government or by the central government, then also there is a possibility of passing a fresh order. You can do so. But one thing that is why on the last occasion I asked you, actually, are you serious? Because of the fact that he has been caught with 605 grams
Yes.
of heroin, which comes within the ambit of a commercial quantity. What stopped you from filing a charge sheet? And if not possible to furnish this charge sheet, what stopped you for asking for extension? Which means you are not serious. Because a person can very well be already under detention. If he is already under detention, to again detain him for another on the ground of preventive detention, does it make sense? He's otherwise entitled to the default bail, as you have not asked for, because 180 days is long over. Therefore, you need better grounds. If you see the judgment in the case of the Manipur judgment of the Supreme Court, when they were dealing with the judgment in Renu, and the question arose as to whether there was a requirement of recording of reasons to that effect. The Supreme Court said that you are to explain why he was required to be detained in spite of that fact that he is in judicial custody. Neither it is there in your grounds of detention. The day before yesterday's, the second case was better. Or is it mentioned in your affidavit why it was necessary? Let us see.
Para 6, clause A. I have explained in this paragraph regarding the subjective satisfaction.
Where?
Para 6, clause A.
What does it say?
Merit.
No, where is it that he is likely to get bail?
That's
Not a single whisper.
yes, that
Then-
specific has not been given. But the why the detention order was issued? This is
No,
the
those are
satisfaction.
different grounds. In fact, this makes it very clear why the judgment of the Supreme Court should not
My
be
lord-
brought into service.
It is the satisfaction.
The satisfaction
Yes.
when therefore a person who is already in custody is already in custody in that particular offense, where getting a bail is very difficult, taking into account one has to get the benefit under 37B 1 and 2, which is not there. Getting a bail is very difficult. Why was it necessary? I would have understood that now you think, become more wise and pass some orders to that effect. That is your lookout.
So my lord, my submission is I'll be relying on the affidavit filed by this affidavit in possession.
Okay.
Para
then
6.
We pass the order.
Yes, and
The instant repetition under Article 2 to 6 of the Constitution is filed by the who? Who is that person? Petitioner is who?
The father of the detainee.
Is
Ashok.
filed by the father of the detainee. That is Mr.
Ashok
Thoru Thaulu.
is Thorathauli is the
Spelling is
detainee.
over there. THORHU উপরে দুটো dot আছে। Thauli. For short, bracket there, hereinafter referred to as the detainee. Challenging the detention order dated 26/7/2023 comma the rejection of the detention order of the number 1 by the order dated 16/10/2023, as well as the confirmation order dated 19/10 comma semicolon. The confirmation order dated 19/10/2023 issued by the respondent number 1, as well as the extension order dated 24/1/2024. From the materials on record, it reveals that on 31/5/2023, the detainee, along with 3 others, were stopped by the police personnel near Kusama check gate. From the materials on record, it reveals that an amount of that on a search being conducted, 50 numbers of soap cases containing heroin weighing 650 grams approximately was recovered from the manually built chamber in the luggage booth of the vehicle. On the basis of the same, search, an FIR was lodged which was registered and numbered as narcotics cell. What is the number? Narcotic cell PS case number. Narcotic cell.
9 of 2023.
What is the number? Narcotic cell.
0009.
Narcotic PS case number 0009/2023. Under sections 21C, bracket small c, /60/29 of the Narcotic Drugs and Psychopathic Substances Act 1985, for short, the Act of 1985. The detainee thereupon continued to remain in custody. On 12/7/2023, the additional DGP bracket L and O bracket close Nagaland issued a communication to the Secretary Home Department, Government of Nagaland, proposing for the detention of the detainee under the provisions of Prevention of Illicit Traffic in Narcotic Drugs and Psychopathic Substance Act 1988, for short, the Act of 1988. The grounds of detention, so mentioned in the proposal, where that the detainee during his interrogation admitted to carry out illegal trafficking of narcotic drugs and psychopathic substances in and around Dimapur town The second ground was that the detainee used his vehicle for transporting narcotic drugs and psychotic substances from Senapati, Manipur to Dimapur, Nagaland. The third ground was that the state of Nagaland lies within the area highly vulnerable to such illicit traffic, as explained under section 10 bracket small Roman 5 bracket close again bracket open small c bracket close of the Act of 1988. The fourth ground is that if the detainee is bailed out, he is likely to indulge in illegal trafficking of narcotic drugs and psychotic substances. The fifth ground was that from the statement of the detainee, it revealed that he is continuously engaged in trafficking of contrabands, and all likelihood he is to continue to indulge in illegal trafficking of the contraband, and hence it was required that he be prevented from the same. On the basis of the said proposal, dated 12/7/2023, the respondent number 2 passed the detention order under section 3(1) of the Act 3 bracket 1 of the Act of 1988. The grounds of detention was detained by an order dated 26/7/2023. It is admitted the fact that the said order of detention was served upon the detainee on 26/7/2023. Same date?
Yes.
26/7. Along with the grounds of detention. In terms with the said grounds of detention, it has been mentioned that 50 numbers of soap cases containing narcotic drugs weighing 615 grams approximately were found concealed inside the manually built chamber in the luggage booth of the vehicle bearing registration number AS01AZ/9428 belonging to the detainee. And the police investigation had revealed that the seized drugs belonged to the detainee. It was mentioned that the detainee had engaged in transportation of narcotic drugs from Senapati, Manipur to Dimapur, Nagaland on 5 occasions since April 2023 for illegal gains, which shows that the detainee detainee's involvement in interstate networking of drug trafficking. It was further mentioned that during the course of investigation, it revealed that the detainee had been involved in illegal trafficking of narcotic drugs and psychotropic substances and marketing the contraband in and around Dimapur, conforming to the acts under Section 2E of the Act of 1988. The detainee, further to that, it was stated that the detainee was presently under judicial custody, and on the basis of the materials placed before the detaining authority, the said authority was satisfied that the detainee was likely to indulge in similar prejudicial activity unless prevented from doing so by an appropriate order of preventive detention. It is on these grounds of detention that the petitioner, that the detainee was detained. The record further reveals that the matter of detention of the detainee was referred to the advisory board on 10/8/2023, and the advisory board submitted its report on 12/9/2023, wherein the advisory board had observed and opined that there was sufficient cause for preventive detention of the detainee under the Act of 1988. The detainee submitted representation on 26/9/2023 to the respondent number 1, that is the Chief Secretary, Government of Nagaland, the Joint Secretary, bracket PITNDPS /COFE POSA, all caps D, bracket close, Ministry of Finance, Department of Revenue, Government of India, as well as the Chairman, Advisory Board of the under the Act of 1988, and also to the AIG Prison Central Jail. It is apparent from the records as well as the affidavit so filed by the respondent number 2 that the said representation was duly received on 26/9/2023. The record further reveals that the detaining authority disposed of the said representation on 3/10/2023. However, the state government, who had the power in terms of Section 12 of the Act of 1988, disposed of the said representation by an order dated 16/10/2023. It is also averred that the central government till date have not disposed of the said representation. Averred and alleged that the central government have not till date disposed of the representation. Be that as it may, it is also relevant to take note of that on 19/10/2023, the state government, through its chief secretary, through the Chief Secretary, Government of Nagaland, had confirmed had extended the detention order, had confirmed the detention order with effect from 26/10/2023 till 25/1/2024. Further to that, on 24/1/2024, the said detention order has been further extended up till 25/4/2024. The petitioner, who is the father of the detainee, being agreed, have therefore approached this court seeking the reliefs as already above stated. The instant petition was filed on 12/12/2023. Subsequently, in view of the issuance of the extension order dated 24/1/2024, the petition was amended by filing, amended, and the amended petition was filed on 19/2/2024. The record further reveals that the state that respondent numbers 1, 2, and 3 have jointly filed an affidavit in opposition on 7/2/2024. The board judgment is the same. This court also finds it relevant to take note of that the instant writ petition was taken up for consideration on 21/2/2024, wherein this court had sought for instructions from the government advocate, Nagaland, as to whether charge sheet has been filed in the narcotic PS case number 0009/2023, and if not, whether the special court had extended the said period in terms with the proviso to subsection 4 of section 36A of the Act of 1985. Today, when the matter has been taken up, the learned counsel appearing on behalf, learned government advocate had submitted that no charge sheet yet has been filed, and he has no information as to whether there has been grant of any extension by the special judge in terms with the proviso to subsection 4 of section 36A of the Act of 1985. In the backdrop of the above pleadings, as well as the pleadings, this court finds it relevant. This court have also heard the learned counsels appearing on behalf of the petitioner as well as the respondents. It is unfortunate to take note of that neither the respondent number four, Union?
Yes, Union is.
The respondent number 4 have neither appeared nor have cared to file any affidavit in opposition. Though notice was received by the standing counsel of the respondent number 4 on 14/12/2023. The submissions made by the learned counsel for the parties have been duly taken note of. And the questions, issues, and the points for determination which arises for consideration before this court, before us, are number 1, whether the detention order as well dated 26/7/2023, as well as the consequential orders which have been passed, requires an interference on the ground that the same have not been, on the ground that the same have not is exercised. Now requires interference from this court on the ground of being issued without having the subjective satisfaction of the officials concerned of the detaining authority. Number 2, whether the non-consideration, the delay in consideration of the representation by the respondent's state government is fatal to the detention order. Number 3, whether the non-consideration of the representation by the central government is fatal to the detention order. Number 4, as to what relief or relief the petitioner herein would be entitled to. We come back after 5 minutes. For determining the first point for determination, the question which is required to be taken note of is as to whether the detention order, comma, the confirmation order are required to be interfered with on the ground of non-application of mind. For deciding the said aspect, this court finds it relevant to take note of a recent judgment of the Supreme Court in the case of Amina Begum versus State of Telangana and others, reported in 2023, 9 SCC 587. Wherein at paragraph number 28 and its subparagraphs, the Supreme Court enumerated the circumstances when a constitutional court would be entitled to examine the legality of the orders of preventive detention. In paragraph number 29 of the said judgment, the Supreme Court observed that if the court finds that the exercise of the power to be bad and or vitiated, applying any of the tests which were enumerated in paragraph number 28, thereby rendering the detention order vulnerable, it shall be the duty of the constitutional court for righting the wrong. Righting the R-I-G-H-T-I-N-G, righting the wrong. Paragraph 28 and 29 of the said judgment, being pertinent to the issue, is reproduced herein under. Next. From a reading of the above quoted paragraphs, it would transpire that the writ court would be within its jurisdiction to examine as to whether the detention order was based on requisite satisfaction, comma, albeit ALBE, subjective, comma, of the detaining authority, inasmuch as absence of such satisfaction as the existence of a matter of fact, comma, upon which validity of exercise of the power is predicated, comma, would be the sine qua non for the exercise of the power not being satisfied. It was further observed that the Constitutional Court can also examine as to whether, in reaching such requisite satisfaction, comma, the detaining authority had applied its mind to all relevant circumstances, and the same is not based on material extraneous to the scope and purpose of the statute. The Supreme Court further went on to observe that the satisfaction which has to be arrived at has to be on the basis of the existence of a live, proximate link between the past conduct of a person and the imperative need to detain him or is based on material which is stale. In the backdrop of the above proposition, well settled by the Supreme Court, let this court consider as to whether the preventive detention order ought to have been passed in the instant case, that too when the detainee was already in custody, or for that matter, whether the non-consideration of the fact that the detainee is already in custody would have a vital bearing on the subjective satisfaction arrived at for passing the detention order. Next. In the case of Dharminder Sugandh Chand Chelawat versus the Union of India, reported in 1991 SCC 746, the Supreme Court observed that an order of detention can validly be passed against a person in custody, and for that purpose, it is necessary that the grounds of detention must show that, number one, Roman 1, the detaining authority was aware of the fact that the detainee was already in detention, semicolon, and Roman 2, there are compelling reasons justifying such detention despite the fact that the detainee is already in detention. The Supreme Court, in the said judgment, further clarified that the expression, inverted comma, compelling reasons, inverted comma, close, in the context of making an order for detention on a person already in custody, to mean that there must be cogent materials before the detaining authority on the basis of which it may satisfy that A, the detainee is likely to be released from custody in near future, semicolon, and B, taking into account the nature of the antecedent activities of the detainee, comma, it is likely that after his release from custody, he would indulge in prejudicial activities, and it is necessary to detain him in order to prevent him from engaging in such activities. Next. We further find it relevant to take note of another judgment of the Supreme Court in the case of Amrit Lal versus Union of India, reported in 2001 1 SCC 341, wherein the detaining authority recorded its satisfaction for detention under the National Securities Act 1980, in view of the fact that the person who was already in jail was going to move a bail application. The Supreme Court observed in the case of Amrit Lal Supra that although in the grounds of detention it has been mentioned that there was a likelihood of the detaining moving an application for bail, comma, for which the detention was necessary, comma, there must be cogent materials before the authority passing the detaining order that there was likelihood of him being released on bail. This judgment is very pertinent for the purpose of the instant case, taking into account that in the proposal which was submitted on 12/7/2023, as well as also in the grounds of detention, there is only mention that the detainee was in judicial custody. There was no mention whatsoever that there are strong circumstances which exist that the detainee is likely to be released on bail. Next paragraph. It is also pertinent to take note of the judgment of the Supreme Court in the case of Gita versus the state of Tamil Nadu, reported in 2006 7 SCC 603, wherein the Supreme Court observed that the detaining authorities should be aware that the detainee is already in custody and is likely to be released on bail. The conclusion that the detainee may be released on bail cannot be the ipse dixit of the detaining authority. The further exposition in respect to the said proposition of said law can be seen in the judgment of the Supreme Court in the case of Hudiram Kunungzao Singh versus the state of Manipur and others, reported in 2012 7 SCC 181, wherein the Supreme Court called out the three propositions as to when a person who is in jail can be detained under the detention laws. Paragraph 9 of the said judgment being relevant is reproduced here in under. In the backdrop of the above, if this court recapitulates the facts involved, and the facts recapitulates the facts which have already been delineated supra, it would show that the detaining authority, though knew that the detainee was in custody, but there is no mention whatsoever that the detaining authority had reliable materials before it, on the basis of which it could have reasons to believe that there was a real possibility of the detainee being released on bail. And further, on being released, he would probably indulge in activities which are prejudicial to public order. This aspect having not been taken into account while passing the detention order, we are of the opinion that the first point of determination has to be decided, holding that there was no subjective satisfaction on the part of the detaining authority to detain the detainee. Next, moving forward, let us now take into consideration as to whether the delay in consideration of the representation by the state government have rendered the preventive detention, the detention fatal, which is the second point for determination. The record reveals that the representation was duly received by the state government on 26/9/2023. The representation was rejected on 16/10/2023 by the state government. There is no explanation as to why it had taken 20 days for the purpose of disposal of the said representation. In fact, the affidavit which have been filed by the respondent numbers 1, 2, and 3 does not. In fact, in the affidavit filed by the respondent numbers 1, 2, and 3, there is not a single whisper as to why it took 20 days on the part of the respondent number 1 to dispose of the said representation. In the opinion of this court, the delay, the unexplained delay in disposal of the representation in the facts of the present case has to be taken as in the facts of the present case has to be construed to have rendered the detention order fatal. In the Full stop. This goes further next. The third point of determination is as to whether the non-consideration of the representation by the central government have also rendered the detention order fatal. Full stop. This court finds it relevant to take note of Section 12 of the Act of 1988, which stipulates that the central government has a power to revoke any detention order. In this regard, this court finds it relevant to take into account the judgment of the Supreme Court in the case of Kundan Bhai, Dhula Bhai, Sheikh versus the District Magistrate, Ahmedabad and others, reported in 1996 3 SCC 194. Full stop. In the same judgment, the Supreme Court observed that the representation so submitted has to be disposed of at the earliest, and if there has been any delay in the disposal of the representation, the reason for the delay must be indicated to the court, or else the unexplained delay or unsatisfactory explanation in the disposal of the representation would fatally affect the order of detention. And in that situation, continued detention would become bad. Full stop. In the same case, it is also seen that the state government therein duly received the representation on 25/8/1995, and it was disposed of on 12/9/1995, and the order was communicated to the detinue on 14/9/95. The Supreme Court observed that the inactivity in taking up the representation for 6 days the Supreme Court observed that the explanation provided in not taking up the representation for 6 days in the counter affidavit that there were 40 to 50 representations pending for disposal, and they were taken up chronologically. Cannot be a good ground Full stop. Further to that, in the said case, the central government could not dispose of the said representation in view of the inputs not being provided by the state government. In that context, the Supreme Court observed that paragraph number 25 of the said judgment, that though black marketing is a social evil and the persons found guilty of economic offenses have to be dealt with a firm hand, but when it comes to fundamental rights under the Constitution, irrespective of the enormity and the gravity of the allegations made against the detainee, the court has to intervene to stop. It was further observed that the gravity of the evil to the community resulting from antisocial activities cannot furnish sufficient reasons for invading the personal liberty of a citizen, except in accordance with the procedure established by law, particularly as normal penal laws would still be available for being invoked rather than keeping a person in detention without trial. Full stop. Paragraph number 18, 21, 18, 21, and 25 of the said judgment being relevant is reproduced hereunder. Full stop. Taking into account that in the instant case, there has been an unexplained delay of disposal of the representation by the state government, and further, the central government till date have not disposed of the representation. We are of the unhesitant opinion that the detention order and the consequential and the further consequential orders have become bad on account of the delay in disposal of the representation, as well as the non-consideration by the state government, as well as the non-consideration of the representation by the central government, for which the detention order, as well as all consequential orders passed thereafter, had been rendered fatal. Next. In the backdrop of the above analysis, let this court therefore take note of what relief or the fourth point of determination as to what relief or reliefs the petitioner herein would be entitled to. First, in view of the above analysis, this court, we set aside the detention order dated 26/7/2023, the order dated 3/10/2023, by which the special secretary, by which the respondent number 2 had rejected the representation of the petitioner. Why do we have to set aside these? This has become inconsequential. We set aside the detention order dated 26/7/2023, the confirmation order dated 19/10/2023, as well as the extension order dated 24/1/2024. In view of the setting aside of the detention order, as well as the confirmation and the extension order, nothing further requires to be decided in respect to the orders impugned, that is dated 3/10/2023 and 16/10/2023. This court, no, this court further makes it clear that this court, however, is not inclined to release the detainee as the detainee still remains in custody in connection with narcotic PS case number 0009/2023. This court, however, observes that the release of the detainee shall be subject to such orders to be passed by the jurisdictional court in respect to narcotic PS case number 0009/2023. With the above observations and directions, the petition stands allowed.
Much obliged.
For orders, item number 2.
Yatte mai upar.
Please, my lordships, this honorable court's judicious application of mind with reasoning is well known, and I just want to present only on 3 points. I don't want to argue on the matter because there is no such kind of a fact of the case. It is everything is available on record, lordship. Here, the only issue, and with 1 or 2 authority, I will just close my argument, lordship. Here, the petitioners allow winning or losing is secondary, lordships. However, here the crux is that in between 641 days, 2 years and 9 months.
Just 1 minute.
In between 41 days, lordship, when the advertisement was issued, and at the stroke of a pen by the impugned letter, when 4 years future of the respondents' appellants have been struck off. Now, lordship, whether there is liability in not addressing the lacuna in between, because here the question is, the legal procedure is that they issued corrigendum addendum afterwards, but even then, the advertisement was served to all the officials of the department, all around 8 of them. This advertisement was served by the NPC to the respondent government, lordship. So, whether they are liable, that is one aspect in not addressing it, not issuing corrigendum, otherwise the petitioners will not be victimized. That is one aspect. Second aspect is that the cabinet OM issued on 24/2008. There is a gap, after a gap of 27 days, lordship, of issuance of the notification 24/11/2008 for the graduate teachers, and after a gap of 27 days, the cabinet set, and they decided that even postgraduate teachers will be given relaxation of 5 years, and issued notification 18/2010, lordship. After a gap of 1 year and 3 months, this notification came out in 2010, the cabinet decision, lordship. So, in between, lordship, 2008 to 2010, when PGTs, a class of employees, never availed the benefit of 27/10/2008 that was issued for the that was issued for the graduate, for primary teachers and pre-primary teachers. They did not avail the benefit of this other class of employees. Lordship, it is remotely, whether they can be covered with retrospective effect. That is the second point that I leave before this honorable court. Lordship, the
Madam,
third,
if I may interfere now.
Lordship,
You see, the issue which I could understand
Yes,
on the
Lordship.
last occasion
Lordship.
was there was an advertisement
Lordship.
issue wherein it was categorically mentioned that there would be a relaxation
Yes, Lordship.
for a period, for thereby granting them that those people who did not have the BA, they
Lordship.
would be allowed 5 years to complete
Exactly,
it.
Lordship.
Now, pursuant to that, a selection process takes place.
Lordship.
You have been selected, and the recommendation is being made by the NPSC.
Lordship.
Now, it is the stand of the respondents that look here, there was a relaxation notification of 2008.
Lordship.
And as per that, the relaxation was only given for a period of 10 years.
Lordship.
And as such, it expired in 2018.
Lordship.
And without the respondent, expired in 2018, and without taking that aspect into notice, the NPSC went ahead with the advertisement.
Lordship.
And as such, we don't recognize this relaxation which has been given by RIA, and we are the appointing authority, and as such, we are not bound by the recommendations
Lordship.
so made.
Exactly.
This
Lordship.
is their case.
That is their case.
Now the question arises twofold.
Lordship.
First is as to whether what is the scope of means once an advertisement is issued
Lordship.
at the request of the respondents,
Lordship.
because they must have, because when does the Public Service Commission makes a advertisement? The advertisement is made on the basis of a request being made by them saying that these are the posts which are available, so
Lordship.
kindly we want to fill up this.
Lordship.
Now, in that requisition which is being made to the NPSC,
Lordship.
and on the basis thereof, when an advertisement is made, would the state government be bound by that advertisement?
Lordship.
Because this is made at the requisition. And the state government did not do anything, even after the advertisement or the corrigendum, nothing was done.
Nothing.
But only later on, when the recommendation is being made.
Lordship. That is
Your first point.
That is my first point. Exactly.
The second question is, so therefore, the question is whether the relaxation which was granted
Lordship.
could now be deemed to have been extended
Lordship.
or not looked into, or it will be deemed to be extended till this period,
Lordship.
because they have not done it, did not say anything.
Did not say.
Yes, yes, there is a question which the learned single judge says that a person being recommended does not have a right. But the question also, we also feel out here that you may not have, you have a right, you may not have a right for appointment. There's no fundamental right for appointment. But you have a right to be considered for appointment, and that consideration has to be not non-arbitrary.
Lordship. Lordship.
So that's your submission, I suppose.
That is my submission. Adding to that, Lordship, notification 18 February 2020 has not been superseded by any other notification or OMs till that. And if there be no application of this notification, they are claiming that it is already expired, but they have not issued anything, and KV Chisa committee has not yet reviewed the reservation policy, which is a state policy, Lordship, in the state. And by default, still this notification is enforced in the state for the whole state, Lordship. So that is, and my Lord was saying that it will amount to negative equality, but Lordship, in your wisdom, knows that negative equality applies to those persons who are enjoying negative benefit and then seeking the benefit of negative benefit again. Otherwise, here, if we are to go by this, advertisement was done, there is no relaxation in any of the categories of employees under education department in the service rule. Yet, how they, under what authority they can relax the maths and physics when there is no relaxation. We are all similarly situated. How comes they have been relaxed? They are in general category. And how comes we, the backwards? We have this 18 February 2010, that our case was not relaxed. And with or without clause 4 of 18 February 2010, Lordship, the above can cover us that we are covered by clause 3 of 18 February 2010. Where we are prescribed.
Now, madam, kindly come to page 30. This is some office memorandum given. Of 2016.
Yes, this was submitted to this honorable court after
Yes,
the.
madam, yesterday that matter that I was having it parted. You were there, na? Yesterday's matter, last item.
Yes.
That item, parted item,
Yes,
single
yes,
bench.
for SSA. Yes.
Check out the judgment in Prem Singh. It's a 1994-95 judgment wherein the Supreme Court categorically differentiates when appointment on the basis of a scheme. What happens? And in fact, you will find that judgment in I have delivered one judgment because yesterday while going back then I remember there is one judgment of 2023 3 GLT page 423 or 425. It is a judgment on the name of the judge. Parties are Purnima Hor versus State of Assam. So there, I had taken note of 4 or 5 types of appointments which were being made, of which there is one class known as the Operation Blackboard, which I was referring yesterday. Na? So you see the submissions which have been made and the judgment which was been given. We'll get an answer to what we'll hear. I mean, hearing it on Monday.
Yes, Lordship.
Yes. No, you see, one thing why
Lordship.
I'm saying, kindly come to page 30.
Yes, Lordship, I'm seeing.
This is the office memorandum dated 19th of August 2016,
Yes.
down below, which the single judge has quoted.
Yes, Lordship.
Now, here it says, it has been brought to the notice of the government that the examination for recruitment to the postgraduate in mathematics here could not be conducted by NPSA for some time now due to non-availability of the candidates with the prescribed requisite professional qualification. Therefore, in the interest of the students community who are badly affected due to non-posting of so-and-so and so-and-so in the state, the government hereby relaxes the professional degree of Iman for recruitment as PGT only in maths and physics for a period of 5 years on the condition that the selected candidate should acquire so-and-so within 5 years. Now tell me, why was this required?
When there is 2000.
That was, whatever may be, it was operational as on 2016.
Lordship. Yes.
If we take their stand
Yes,
that it was
exactly.
available till 2018.
Exactly, Lordship.
So why was this required then?
Exactly, Lordship. And they are similarly situated, Lordship. Of course, we are from backward. We have more relaxation than them. This is issued for the general category, Lordship.
So this notification is irrespective of anybody. 2010.
Yes, Lordship.
Irrespective of the subjects.
Lordship.
it is to the tribes.
to the tribes, backward tribes.
Whereas this is irrespective of
Of-
tribes, but to
Yes,
subjects.
exactly.
So this
Exactly.
notification cannot have been brought in for the consideration of the 2010.
Exactly, Lordship. Exactly, Lordship. And which is a policy, clause, sub-clause 5 says, which is a committee will review the reservation policy, the policy of the state. But till then, there is no such, and this is by default. By default, this is still applicable. In other recruitment process, this is being implemented. And even in the
So this clause number 5, has there been any KV
Susa
committee?
Lordship.
No committee till date.
Till that, no, Lordship.
So under such circumstances, your submission that this continues.
If, of course, whichever way, by default, this is being implemented in the state, Lordship. And NPSC maintains the roster system of the backward quotas. That was delegated to the NPSC by notification, Lordship. I have the notification also annexed here. NPSC, the learned single judge say that NPSC is only a recruiting body, but
No, there's no quarrel with that proposition
Lordship,
that the
Lordship.
NPSC would be a recruiting body. There's no quarrel. But the fact is, the non-consideration on grounds which are not in existence
Lordship,
would make it a case of malice in law.
Lordship, exactly. And reservation and relaxation of education qualification are part and parcel here in the state. Lordship, this kind of reservation is not applicable as it is in other states. So it might be a little bit deviating, but the state government made a policy and they issued that all the departments should amend the service rules incorporating reservation policy of the state. And this was issued, this Nagaland School Education Service Rule came into being in 2017, whereas this reservation policy issued by the governor was in existence. And here, even in this NSER rules 2017, Lordship has given relaxation. My lord, I will just for the postgraduate teacher, direct recruitment is page 3.
So if it is considered to be an essential condition,
Lordship,
there cannot be relaxation. So the state cannot relax. There are a lot of judgments.
Lordship.
So then in that case, they couldn't have relaxed for maths and physics also.
That is exactly my point. And they cannot relax even for other graduate teachers also. Since the service rule here, the graduate teachers are also here and no post carries relaxation in the service rule. But this is a policy decision of the state, and as per the notification issued by the state government from time to time, all the service rules are incorporated. So this is the my lord, will kindly see page 4 plus 6. I will just
When was the advertisement issued?
advertisement was issued on 13 November 2019. This was no corrigendum was issued in 3 years, almost 3 years.
Now, number 6 at page 4 of that document.
Yes, sub-clause 6, Lordship.
Yes, subclause 6.
The sub-para, Lordship.
Yes.
Provided that the arrangement of names of the qualified candidates in order of merit shall be subject to the reservation policy for scheduled tribe and backward tribes as per instruction issued by the government from time to time. That is one. And this is also incorporated in B, Rule B for graduate teachers, primary teachers. That is exactly page 6. Page 6, Roman 6. Same, Lordship, even for the graduate teachers. Sub-para, provided that the arrangement of the names of qualified.
We are concerned with PGT,
Yes,
postgraduate.
yes, anyway, just trying to compare and contrast, Lordship. And,
The earlier one is postgraduate. We go by 6.
yes, Lordship. And
Now kindly come to 6A Roman 2.
6A. 6A,
Roman 2. Page 3.
yes. The commission shall advertise the post specifying as far as possible the terms and conditions under these rules and the number of vacancies to be filled up.
Okay. Now when was the advertisement issued?
It was issued on 13th November 2019.
2019.
Lordship.
After this.
Yes, exactly. Then, Lordship, a reservation is here provided under Rule 8. Rule 8. Reservation of posts. It is incorporated in the service rule itself, Lordship. There shall be reservation for the backward tribes of the state, as well as for the physically handicapped against all categories of posts to be filled up through direct recruitment, to the extent and in the manner laid down by the state government from time to time, provided that in the case of reservation for backward tribes, if no candidate is available from a particular backward tribe whose turn has come on the roster, the vacancy shall not be filled up by a candidate belonging to any other tribes. That will suffice, Lordship. This is the policy.
No, this is on the question of reservation.
Reservation.
We are concerned on the relaxation. Because that document of
Yeah.
policy is a relaxation.
So policies of relaxation was issued by the notification 8, 18, 10 and is in force till date, Lordship. That is my humble submission before the Honorable Court. And Rule 32 provides power to relax rules.
That is it. And where as regards the qualification, what is required? Is it mentioned anywhere in these rules?
Yes, Lordship.
What is the
31.
qualification required?
Yes, 31, Lordship. Page 31. Schedule 2, page 31.
The recognized degree shall be granted by the university, recognized by the university AICT. The undue hardship is likely to be caused to any person by the application of any bill. The government shall have the power to relax the application. So therefore, this 2016,
Lordship.
how can that document of 2000 for maths and physics have any relevance in respect to an advertisement done in the year
Exactly.
2019?
Exactly, because notification 8 to 10 is enforced.
The document at page 20,
Lordship.
30 of the memo of appeal, page 30, which the learned single judge have quoted.
Oh, Lordship, Lordship. Yes, exactly.
How is
Lordship.
it relevant? Taking into
Yes,
account
sir.
the advertisement was made in 2019.
Lordship.
And that was a consideration to be taken at that point of time, that as these people were not being found.
Lordship, Lordship. And even for the first appellant, there were two computer science posts were advertised. There was no candidate. So he applied in the general candidate. Though backward reservation is there. And he was the only candidate in computer science. 2 posts were advertised, only one was filled up because there was no candidate. These are the aspects of the present.
And what do you say about the advertisement? When an advertisement is being made at the requisition by the department,
Lordship.
would it be binding unless prior to the completion of the advertisement something is done? Whether the state will be bound by that? Because you see, in many of the circumstances you must have seen that there are many cases where once the advertisement has been issued, later on some new yardsticks will be brought, the Supreme Court interferes and say that you cannot change the
Rules of game
The
cannot
rules
be
of the
changed
game. after the
Rule is
advertisement
made.
has been issued, meaning thereby the state is
They cannot.
made bound.
Yes, Lordship.
If that be so, once the thing has been done, thereby granting
Exactly,
and
Lordship.
relaxation, can they change the rule of the game?
Rule of the game, they cannot. That is, I have the exact citations. The first one is, besides the rules of game cannot be changed. This is the 2014, volume 10, page 521, Lordship. This is also where rules of game, I will come to that, Lordship. Lordship, that is the relevant paragraph is 31. Page 521, Lordship. Relevant paragraph is 31. Principles have been laid down, and I will just read out the operative portions. 31, Lordship. Page 538. In
Yes.
para 32 of Asha's case, the exceptional circumstances which can be examined have been quoted in order to ensure that when any deviation is to be made from the normal rule, such similar principles should be kept in mind by the courts. In para 32, it was highlighted that in the rarest of rare cases or exceptional circumstances, the court may have to mold the relief and make an exception to the cut-off date of 30th September. But in those cases, the court must first return a finding that no fault was attributable to the candidate, that the candidate pursue her right and legal remedies expeditiously without any delay, and that there was fault on the part of the authorities, and that there was no apparent breach of rules, regulations, and principles in the process of the selection and grant of admission. It was also highlighted that where denial of admission would violate the right to equality, the equal treatment of the candidate, it will be completely unjust and unfair to deny such exceptional relief to the candidate. By relying on the said part of the decision, the learned senior counsel submitted that the case of the contesting respondent was squarely covered by the principle of an exceptional case, and therefore the direction of the division bench was well justified. 32. 33, 2, Lordship. Under exceptional circumstances, if the court finds that there is no fault attributable to the candidate, i.e., the candidate has pursued his or her legal right expeditiously without any delay, and that there is fault only on the part of the authorities, or there is an apparent breach of rules and regulation as well as related principle in the process of grant of admission, which
Madam,
would
this is not the point.
then 33, 3, Lordship.
No, madam, the question is whether when the rules have been issued, when the advertisement has been issued at the requisition,
Lordship.
they doing nothing during entire recruitment process. And at the time of appointment, now they are
Yes,
taking up
yes,
this
yes.
issue that these people could
Yes.
not have been recommended, does not have the qualification. and
Exactly,
all.
Lordship, exactly.
Now, wouldn't that amount to changing the game?
Yes, Lordship. So the authority is 2008-3 SCC.
There are new authorities, madam. Very new authorities.
With
Everywhere,
Lordship,
there's so many
Lordship,
new
Lordship,
authorities which
Lordship.
are coming. Yeah. No, therefore, whether they will be bound and whether there is a change in the policy. You see, yes, the question, the learned single judge, in our opinion, is correct on the saying that
Lordship,
you don't have a right of appointment.
Lordship, Lordship.
But the fact remains, when you are being recommended on the basis of the advertisement,
Lordship.
and that advertisement, has that advertisement at any point of time, the state government nullified it,
No.
except by rejecting your appointment.
Yes, exactly.
So if they have not or said that this advertisement is bad or whatever it may be, then in that regard,
Lordship. That is my,
the non-consideration or of your case for appointment
Lordship.
on a yardstick which is not in consonance with the art advertisement, would it be bad?
Lordship. Lordship.
That, however, I don't think the single judge had looked into. What do you say?
Yes, Lordship, others have been considered. There is no relaxation in the service rules, but similarly situated in the same examination, the advertisement was served to the respondent authority, 8 respondent authority, the advertisement, but they did not issue any corrigendum, and now it's already 4 years and 1 month or so. So the petitioners have been victimized, and Lordship, it has affected their whole future, and it may not be in the next, the respondent might change their policy or whatever, but within this perspective, looking at the effect of the effect and circumstances of this case, Lordship, it may be personal to the
Now, what should
petitioners.
we, what is the relief you are seeking in the writ petition?
Lordship, we have been, others have issued appointment orders, so Lordship, my prayer is just that my lord will kindly come to see. I have challenged the letter that was issued on 11/20/22.
For
That
setting,
was why,
for setting aside.
yes,
And
that and impugn class 4 that I have challenged, relaxing with retrospective effect from 2008. However, that can be rectified, or Lordship, with or without.
let's see your
this.
reliefs claim in your writ petition. Reliefs claim in your writ petition. Yes.
No petition. Lordship, direct the respondents to consider the letter 23A22 of the NPSC. NPSC is also a party, but they are performer respondent, Lordship, to consider 23A/2022 of the NPSC and to
So
appoint
we
the
need to mold the reliefs
Lordship.
because we can't direct them to
Yes,
appoint.
yes, yes.
We can only direct them to
Lordship,
consider
Lordship,
by holding that this decision is wrong or right.
Lordship.
But that will be subject to
I leave
after
it.
hearing the
I leave
AAC.
it. I leave it to your Lordship.
Any other judgments? No.
Lordship, I have this rules of game cannot be changed. That is, I think.
Or you
very
want
relevant.
this court should make this exercise
Lordship.
to find out what are the judgments in your favor.
Lordship can add so many judgments that we are unaware or we are not.
Okay, let's hear the AAG.
Raising the question that page 30.
Yes, madam,
Yes.
you said on the last occasion
Yes,
that this principle was very much already there in 2018.
Yes.
In till 2018, it was valid. Then
Yes.
what
That's why,
necessity?
I'm going to explain to this. Why is this 2010 is insubsistent? Why the government brought out 2016 notification? Those who come to page 99. If we read this, it will make the page 99 is the original. The 100 is the type copy. This will make it more clear. Close of 4. 100. This order of relaxation shall be deemed to have come into effect from the date of issue of the first notification relating to relaxation of recruitment policy vide even number dated 27/10/2008 and shall be valid for a period of 10 years. In respect of the backward tribe, it is for 10 years. And in respect of the general category, other Naga tribe, it is for 5 years, Lordship. So for the general category, after the expiry of the 5 years, there were no candidates from who has the professional qualification of BA of Maths and Physics. For which reason 2016 was introduced, Your Lordship. Otherwise, 10 years is for the backward tribe.
But you see, if we read that notification of 2016,
Yes.
it says that
Maths
there are
and
people
Physics.
who are not available.
Yes.
Then
So
why,
that means
if
that-
that be so,
Mm-mm.
can it be said to be a policy decision taking into account that you are having this selection in 2019?
Your Lordship, this is with
Kindly
regard
see the
to
wordings used in 2016.
Yes. Your
It
Lordship,
categorically says that, you see, we are not finding people. So under such circumstances, relax these people.
then Your Lordship may come to the advertisement. This is only with respect to the backlog vacancy. Advertisement is at page 71, then the backlog is at page 73.
Backlog is at page 73.
Yes, 73. Number B, backlog vacancies under various department year 2016. Postgraduate teacher.
Okay,
PhD,
so that is why,
Yes.
this is why.
Yes, this is.
This
for
is
the
in
backlog
terms with that
category.
other one, some other notification where the backlog has to be done in view of this,
Yes,
this thing.
Yes.
Okay.
So this was even in 2019 also they have advertised the backlog vacancy of 2016. Lordship. Yes,
So these are backlog vacancies.
yes, backlog vacancy, yes. So Your Lordship, here the petitioner, they do not have the requisite qualification. And the NPSC, they have recommended them a deviation of the service.
But
rule.
other postgraduate other maths,
Yes,
what have you done?
the maths and all, that has not been advertised in this advertisement.
Physics?
No.
No, for maths, physics.
Lordship, they advertised the post for English, history, political science, computer, media, commerce.
And this page at page
2016,
30,
Yes,
30 is in respect to, this is of 2016.
16 vacancy, backlog vacancy.
For recruitment as PGT only in maths and physics.
Yes,
Now, this at page 30, this notification,
yes.
I understand that for 5 years it was given, but what happened to the others?
Lordship.
If we go by the 18 to
So
2010.
they have 10 years, they have. For the backward tribe.
Only
relaxation is for
those
10
who
years.
were not of the backward tribe, they were,
For 5 years.
no, they were only for 5 years.
Yes. So after the expiry of the 5 years, there were no candidates from the general category who has the professional qualification of BA in maths and
So
science.
18 to 2010 was tribe specific,
Tribe specific.
whereas this is subject specific,
Yes.
irrespective of any tribe.
No, only in respect of general category, only in.
No,
respect
it
of
doesn't
category.
say general category. Where is it says?
Because Your Lordship, if we read together with.
No,
the
how can you
2000
read
yeah.
together this or that? Because if you see that is tribe specific.
Yes, tribe specific.
Here it says anybody.
Okay, Lordship.
Kindly see, does it mention anything?
Yes. For recruitment to the post of place in maths could not be conducted for some time now due to non-availability of candidates with the prescribed requisite qualifications or BEd degree, Lordship.
Therefore, in the interest of students, community who are badly affected due to the non-posting of so-and-so, the government hereby relaxes the professional degree of ED
Yes.
for recruitment as PGT only in maths and so-and-so for a period of 5
5
years
years,
on
yes.
condition. So under such circumstances,
Yes.
therefore, are you saying
Yes.
that 18 to 2010 was modified by this?
No, I'm not saying it's.
No, because here it says we only relax for maths and physics.
But,
If we
Lordship,
read both together,
yes, if we read together, your Lordship.
then one has to hold it that this document takes away the qualification, the relaxation in respect of others. If we read it independently, saying it, yes, 18.2 is tribe specific, whereas 2016 is subject specific.
Okay, we can take it that way, your Lordship. Tribes
Because that has to be done in
yes,
there.
yes,
Because if we read together,
Yes,
that means you did not have relaxation after 2016 in respect of any other subject. Because here the word, see, the government hereby relaxes the professional degree of BEd for recruitment only in maths and physics.
yes, yes.
Meaning
only-
thereby that all other, if we read both together, it will go. The 18 to 2010 had lost its existence in view of this.
So, your Lordship, I see that even 2010 is in existence, and even 2016 is in existence, because 2010 relates to the backward tribes. But 2016 relates to the general tribe. General
Where is it
tribe.
mentioned?
Because, Lordship, it says for the general, it's only for 5 years.
No, there is no general in it, not a single word. How do we apply this or that?
Lordship, if we read it this properly, your Lordship, because for the general category, for the backward category, whether there is a notification came out by the government or not, this will, until and unless this notification is modified, this will stand. So the general category will enjoy the relaxation for a period of 10 years.
Where is it mentioned?
Here at clause 4.
General.
Other
Let's-
Naga tribe, because other Naga tribe.
No, is it mentioned other tribes somewhere?
Yes, other Naga tribe, yes.
Huh?
Because we have the.
No, no,
backward
no.
tribe-
Where? No, in 2016, where is it mentioned?
It has not mentioned.
Then,
Lordship.
how do we say? Yes, we can't do that. Okay, that is one. Now the second thing is, you had the advertisement
Yes.
in 2019.
19, yes.
You have seen that advertisement. Why didn't you do anything? The
No,
advertisement was issued at your request.
At our request,
Because there cannot be the NPSC has no business to issue an advertisement without asking you.
Lordship,
Now, if you see, when an advertisement is issued, if I know it, it is prior to the advertisement, a draft is submitted to you. It has to be. It has. It has to be submitted to you. Once it is being submitted, you say, okay, then only you publish. Nobody does anything. If you see the file, you have the file. Who is appearing for
NPSC, no, no.
there is no standing council, nothing. You have made the NPSC a party,
Lordship.
NPSC? whatever maybe, you have made them a
Lordship.
party. Because NPSC requires to be heard. Because NPSC, you see, get the records of that. We will see that prior to that, there has to be a draft. And this draft is formalized and then the NPSC publishes.
Then, Your Lordship, even the relaxation is already out. The relaxation notification already expired in the year 2018.
Understood, but when the advertisement has been issued and thereby you have categorically mentioned, you have allowed the advertisement.
Because we have, Your Lordship, we have in the requisition format, we have categorically stated that relaxation is only in respect of maths and physics.
Show me that.
Yes. Page 119, this is the format, Your Lordship.
For filling up the post of the government higher secondary and
Secondary
Imam.
school, yes. Then page 120.
This
Your
was
Lordship,
issued when? When was the advertisement issued?
advertisement is 11/2019.
Or this is before that?
Yes. So page 120, number 5. Number four, even your lordship, name of the department, such and such, specify service rule applicable. The Nagaland Service Education Service Rule 2017, particular of post to be filled up direct recruit qualification, postgraduate with at least 50 marks or an equivalent relaxation by such and such candidate master degree level in the relevant subject from recognized university. Essential qualification is postgraduate with B.Ed, lordship. Training, B.Ed, relaxation for maths and physics as per OM such and such. Then even in the second requisition, your lordship, the requisition format is at page, the other one is page 154. This is October 10, 2019. We have specifically mentioned that 155, relaxation is only in respect of maths and physics and postgraduate with B.Ed, and the Nagaland Service Education rules will apply.
If my lord will also produce page 131, NPSC rules.
So even NPSC rule also it says B.Ed, then aggregate marks. For the NPSC, they have committed a mistake. They are also admitting that they did a mistake.
Yes, we'll come back.
Lordship.
Or should we hear some other day? Because there's a single bench. We are having a lot of difficulties out here. I'm taking it up. You see, I have only,
Just
we'll hear it after 2.
Lordship.
Yes. Yes. Simultaneous, yes, simultaneous, yeah, that's like speaker. Here. And partner single lens to another partner company. Like to start with all. And single single. Single lens. One, two, partner. So we just go. Gimana?
After government, some it was.
You already filed What is two? 120, I think. I'm four. Facebook later, three. Or. We give it easy probably. A little bit lower session. There's only one gun name. Yes. Please be one. Where trying to reach it all. The border is for the people when I go. You're coming to the And we all the vice president in there. But what? For one single bench. And Dorito, if the single bench seats. Also, my rest takes it two. Yeah, the cost is two. That's so part of this.
I will take you to page 97. This is the explanation given by the MPAC. Page 97. This is dated 23/8/2022 to the Commissioner and Secretary to the Government of Netherlands School Education Department, Kohima, Netherlands. Recommendation for appointment to the post of postgraduate teacher. In inviting a reference to your letter date number such and such dated 11th August 2022 on the subject cited above and your department's query as to how 3 PGT candidates, one each in computer science, commerce, and English, without the requisite training professional qualifications of Bachelor in Education were recommended to the post of postgraduate teacher under School Education Department. I am to clarify that clerical mistake has been committed at the time of releasing advertisement. So, Your Lordship, even the MPSC, they says that it was a clerical mistake at the time of releasing the advertisement. Then the second para, Your Lordship. Now that recruitment process is completed and victimizing the candidates at this stage for no fault of theirs would not be appropriate. Moreover, it is a clear case of mistake committed inadvertently, Lordship. Then the last para, in the light of the above stated facts, I would make an earnest request to the department to consider the matter as unintentional error and initiate for relaxation of BA as a basic qualification for recruitment be extended only for this particular year, that is 2019, for a logical conclusion. So, Your Lordship, we have given everything in the format. It is the MPSC who did the mistake and they recommend the petitioner. So, Your Lordship, when the petitioner does not have the requisite qualification, where is the question of a direction for the appointment, Your Lordship? So, the learned single judge, he has passed fairly the judgment in order, Your Lordship, in dismissing the writ petition.
Now, this Nagaland service, kindly come to page 98.
98.
Yeah. Says
Yes.
the requisite qualification for the post of postgraduate teacher is postgraduate with BEd.
Your
BEd.
Lordship, which page?
Page 98.
98.
Yeah.
98.
98.
Mine is, okay. It's a government letter to the MPSC.
Yes, yes.
Yes, yes.
That as per the Nagaland School Education Rules 2017,
Yes.
the requisite qualification for the post of postgraduate teacher is
Graduate with B8.
with BEd.
Yes.
Now, where do we find this?
The postgraduate with B8, this one will be in, even in the requisite.
No, these are the rules.
Yes,
Yes.
yes, yes.
So kindly show it from the rules. Where is it?
Yes. Lordship, may I come to page 31. Page 31, the last serial is serial number 8, postgraduate junior grade 3. Then the right column, there is Lordship, the qualification is given. Number B, Bachelor of Education, BA Education, BSc Education from any National Council of Teacher Education recognized institution, Your Lordship.
So both.
Yes,
And-
both, yes, postgraduate with Bachelor of Education, Lordship.
Now, could there have been a relaxation for maths even
Lordship.
No,
in view of this?
Relaxation is only in respect of the backlog of 2016.
But can you?
We have relaxed the
No,
rules,
no,
Your
maybe
Lordship.
backlog,
Yes,
but as of that, as on the date on which the notification advertisement was issued,
yes, yes,
has to be regulated on the basis of the advertisement, the rules which was
in force.
force.
Yes,
So the rules in force were these.
yes. So we have relaxed the rules under section 32, under rule 32. where
You
we have the-
relax
For
prior
the-
to that.
Yes, yes.
And can you relax qualification, the requisite qualification? No,
Yes, yes,
that's the law.
exactly, Lordship.
So for maths and physics also, you could not have.
Yes, 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 because after the coming into force of this rule, yes, yes, yes. So, but even that was, that notification was given in the year 2016. So that relates in respect of the backlog vacancy of 2016, Your Lordship, when the service rule was not in force. Yes,
No, maybe,
yes,
but when you made the requisition,
yes.
could you have made a requisition giving relaxation to maths and physics in view of this?
Yes, yes, Lordship.
Not possible.
Not possible, not possible, yes.
Even for maths and physics also, you could not have.
Yes, after the coming into force of the service rule, yes.
No, you could not have.
But the petitioner are not from maths and physics,
Selection
they are from
process by recruitment from graduate
English,
and graduate.
commerce and computer science.
And what is the second? Number two is direct recruitment. This is promotional.
Yes, commerce.
One is Roman one is direct recruitment.
Yes,
Roman two is promotional.
yes,
And the promotional thing, they also require B.Ed.
they require B.Ed, yes.
At the master level with B.Ed and has rendered a continuous service.
Your Lordship, everything is mentioned again in page number 7.
7.
Yes, page number 7, this is rule 7. Rule
Se-
7B.
B, yes.
Educational qualifications. They require educational qualification for direct recruitment to the post of postgraduate teacher in arts, humanities, science, social science, commerce, education, and language shall be as follows. A. Postgraduate with at least 50 marks or an equivalent, relaxable by 5% for scheduled tribe, scheduled caste, differently able candidates at the master degree level in the relevant subject from a recognized university. And B, Bachelor of Education, B.Ed from any National Council of Teachers Education recognized institution. Then the number 2.
So under such circumstances, even 18 to 2010 has been already done away with.
Yes, after the coming to force of this service. rule.
This,
Yes.
unless there is a specific, unless this power of
Yes.
reservation is given. But the
Yes,
power
yes.
of reservation is only limited,
Yes.
but the educational qualification cannot be dispensed
True,
with.
true, true.
Let us see the relaxation which Madam has shown us.
Page 20.
29, Lordship.
How to relax, where undue hardship is likely to be caused to any person by the application of any of the shall have the power to relax the application of the rule in respect of that person for good and sufficient reason, which shall be without prejudice to the interest of any other member of the service. Now, for maths and physics, if you relax, then in that case, are you not violating for others
other subject.
No, not for, even for maths and physics teachers, other teachers who are to be promoted. From graduate, these people can be promoted. If we see that page, you have shown it to us,
Yes,
na?
yes, yes.
That particular page
Page
31,
31.
32 or something.
Mm.
This 32,
Yes.
there are two things. One is direct recruit and the other is recruitment from lower grades.
Lower grade.
The lower grades also require B.Ed.
Yes, yes, yes.
So under such circumstances, if you do for maths and physics, you will be,
No, there won't be any lordship discrimination or whatever to them, because even for the graduate teacher also B.Ed is a compulsory.
that is what.
Yes.
So for postgraduates,
Yes.
if you are doing it,
Mm.
how can you relax for maths and physics? You
Lordship,
can't.
yes, yes, yes. If we go strictly by the service rule, yes.
We
But
have to
Your
go.
Lordship, we have to take into consideration the interest of the students also, because of the non-availability of the professional.
Then you have to amend these rules.
Yes.
These rules are statutory rules.
Yes.
Under
But
309.
now too, we don't have facing that problem, Your Lordship. Even for 2016 is only. for
Ah,
a
these
period
are
of 5 years.
309
It
rules.
Already expired.
Huh?
2016 also already expired for a period of 5 years. So it expired 16, 17, 18, 19, 21. By 21 it expired. Lordship.
No, but that is a
Yes.
different thing.
Yes.
But these are 309 rules.
True, true.
So which
But the
have a
petitioner is
statute
also not harping on that issue. Her only prayer is
that they should be also given the benefit.
benefit
That
of
is
the
negative
2010.
equality.
She is challenging the 2010 notification. If at all during the existence of that notification had she challenged, that would be a different issue. But after the expiry of that notification, she is challenging. So can she challenge a rule, a notification when there is no existence?
But can't you argue that even if assuming there is that notification also,
Yes. After
That-
coming into
no,
force,
let us
it is
assume-
not applicable. Yes.
yeah,
Mm.
even assuming 18 to 2010 was alive,
Yes.
then also
No.
in view of these 309 rules,
Yes.
which are statutory, that
True.
cannot override an executive instruction.
Exactly. So, Your Lordship, in our
Because this relaxation on 18 to 2010
yes,
would be at best an executive instruction
exactly,
in
exactly.
161.
Yes,
Huh?
yes.
So this obviously cannot
This
override
rule will-
309.
Yes, prevail, Lordship. Even in page 120, that is our format. Also, we have categorically stated that page 120.
Page
120.
115.
Yes, the requisite format.
150.
120.
Oh,
120.
yes.
Specifies service rules applicable. The Nagaland School Education Service Rule 2017.
Where? Now
Serial 2.
specify service rules applicable.
The Nagaland School Education Service Rule 2017.
Now let's see in the advertisement, did they do that?
Advertisement is at page 71.
71.
So they make a mistake, and the NPAC is also admitting that it is a clerical mistake, Your Lordship.
And they also did not mention anything in the advertisement that these Nagaland service rules shall be
Yes,
applicable.
so everything they have make it a mistake. That's what the NPAC is also stated in their letter to our letter asking them for clarification. So, Your Lordship, there is no grievance of the petitioner against the state government. If at all she has a grievance, she should claim damages from the NPAC. That's all. Yes.
In absence of NPSC, now you are saying that
No. On
they
the
don't
other-
have anybody to
No,
provide.
she-
No, on the
The
other.
NPSC in their affidavit, they are standing by the 2010 notification. They stand by that. That's why.
In the
they're
NPAC, in the
protecting.
Where is the affidavit?
Their affidavit is at page 141. Their affidavit also, they have stated that it was a mistake, Your Lordship. At page 142. Paragraph 4. Para 4, therefore, the last few lines, therefore, the commission deemed the relaxation of 10 years under the said notification to be still valid and accordingly issued the advertisement in November 2019, which is clarified as clerical mistake, Lordship. So NBAC is also admitting that they have committed the mistake.
Let's see the corrigendum. What does it say?
27.
Lordship, that is at 77. Next sheet, Addendum Corrigendum.
No, there's a corrigendum on there. The commission
page,
in the
145.
it was not in an issue, and therefore the commission deemed that as relaxation under the CR to be still valid according to the commission calling the issue that by way of addendum corrigendum dated 27/1.
If Lordships can also peruse 147, the last
Yes, 146,
What?
147.
147, Roman 3,
Roman.
3,
Ah.
last. This is addendum. They have also relaxed MA education and in item number 52, MSc Physics, who does not possess B.Ed will require to complete the B.Ed course within a period of 4 years as their own expenses, beyond which they will not be eligible for further increment promotion to higher post. This is with regard
No,
to,
in this corrigendum, did they mention anything about what is that item number? This 77. We are concerned with item number
this
40,
concern with NCA
33, na? 32, 27, 30 and 32.
27 to 32.
What
They
does
have
this
not
item
mentioned
number
here. And what my
27?
learner friend is referring is in respect of other department, not in respect
in
of
colleges,
education.
Lordship, I'm
No.
just,
Where is it? Where is it?
Outside
Educational
education.
qualification item, master degree from recognized in year clearing shall not be required for such civil. How is this corrigendum relevant?
It has no relevancy with the present.
They have
matter,
just said
yes.
that we have issued a corrigendum.
Yes.
But they are in this affidavit at paragraph 6, they again support the case of the petitioners.
Yes, no, they didn't. They didn't support.
Yes, see, paragraph 6, page 143.
With regard to the specific, only for primary. Yes, that is what they have stated, Your Lordship. They took it that 10 years. with
Therefore, the
effect from-
NPSC keeping in view the relaxation of undergoing a Iman for Iman and after being qualified and they will be operative only for the deponent being fully satisfied that the case of the petitioner falls under the notification dated for appointment to the post for which they have applied, have duly recommended their names to the Iman for which the later was declared by the Seer.
Yes.
So they are supporting the case of the petitioner.
Yes, whatever be, even if the support also, we are the appointing authority, whether to accept or not to accept is depend on us, Your Lordship. So when they do not have the requisite qualification, who are to teach the future generation of the society, Your Lordship, we cannot appoint them.
Was this the single judge hold?
Lordship,
Single judge
uh,
dismissed it on what grounds?
NPSC is just a recruitment body, and consideration of the petitioners deviates from the service rules of 2017. So I have taken my lordships to the service rules, and this service rules, was framed, the latest notification, that is 4th September 2015. This is the basis that is latest, and lordship herein, that is page 42, annexure 3. It says, it is hereby ordered and reiterated that all departments and all appointing authorities shall strictly abide by and follow the above existing government reservation policy.
Right to consolidation. Where's the right to compulsory education act?
Lordship,
Yeah.
2009.
Because I think in that act,
Yes.
the minimum qualification is being given also. Requirement of B.Ed.
Lordships, section 23.
2009, na?
Lordship, 2009.
Any person possessing minimum qualification as
Within
laid
4
down in the
years.
academic authority authorized by the central government by notification shall be
Yes.
eligible for appointment as a teacher. When the state does not have the adequate institutions offering courses of trainings in teacher education and so on, as laid down in the central government may deem necessary by notification reflects the minimum qualification required for appointment as a teacher for such period not exceeding as may be specified in that notification. Provided that the teacher who is at the government this minimum qualification as laid down
Otherwise, your lordship,
So kindly come to, you have these rules? No. You see, the minimum qualification of the teachers as per the 2010 rules of the central government says that the central government shall within 1 month of the appointed date notify an academic authority for laying down the minimum qualifications for a person to be eligible for appointment as a teacher. The academic authority notified under Sub-Rule 1 shall within 3 months of such notification lay down the minimum qualification for teachers to be eligible for appointment as a teacher in an elementary school. The minimum qualifications laid down by the academic authority referred to in Sub-Rule 1 shall be applicable for every school referred to in clause N of section 2 and 2. Now 2 says school means any recognized school imparting elementary education and includes a school established, owned or controlled by the appropriate government or the local authority. An aided school receiving aid of grant from the appropriate government or the local authority. Now, appropriate government will be in relation to a school established, owned or controlled by the central government or its the central government in relation to a school other than the school referred to in established within the territory of the state government. Now, you have the state rules.
yes, I've asked the lordship to produce on the next day. But the lordship here, ours is we are dealing with the secondary school, not the elementary. The petitioner before this were out to teach in the secondary school, postgraduate.
Higher secondary,
yes,
lordship.
not an elementary.
So this does not apply.
I think so, your lordship. because compulsory education is still up to age 14, if I'm not mistaken.
So then this has to be gone in the 309.
309, so.
There's no way out.
Yes.
No, why I am going into this? Otherwise, I would not have gone into it. Because you see what the single judge has gone.
Yes.
Single judge has gone into the question out there pertaining to that a relaxation was possible in respect of maths and physics. Now, could that relaxation have been possible taking into account 309 rules have come in? Whether at best the notification under 18/2/2010 would have been there in view of the 309 rules.
Lordship, my humble submission, it could be subject to correction, but Your Lordship, that 2016 notification was prior to the coming into force of the 2017
therefore,
rule.
As on your when you made the requisition, you made it very clear it has to be as per the Nagaland Service Education Service rules,
Yes.
which they did not mention in the advertisement. That's a
Yes,
different
yes,
aspect.
yes.
But that was done in pursuant to your requisition.
Yes, in person to our requisition.
Now, the Nagaland Service rules categorically mandates that the function of relaxations can be done against a person for good reasons. Can you rely upon a notification which was issued or an office memorandum issued in 2016 when these rules were not there?
Lordship, because it relates to the backlog vacancy.
Backlog also, can you do that on the basis of those rules which were there at that point of time? Because you see the judgment in YB Rangaya, which says that the filling up of the vacancies has to be on the basis of the law laid down at that point of time, or the rules prevailing at that point of time. That has already been done away with by a three judges bench. Now the law is the rule, the advertisement or the recruitment has to be made as on the date on which the rules are prevalent, not on the basis on which the vacancy arose. So under such circumstances, I think that is what is the name of the judgment, I forgot. It's a very recent judgment. So under such circumstances, the question arises as to at all the maths and physics could have been given. Because why? We have no problem in dismissing the writ appeal. But the problem is, I think, on the grounds and reasons which the learned single judge has given, seems to be an incorrect proposition. The single judge has upheld your actions on the basis that the relaxation was only given for maths and physics. But could maths and physics be given, taking into account that that rule or that office memorandum could not have been there, even for those backlog, because it is dependent on when you go ahead.
But Your Lordship, if interfering into single judge judgment, because already the